Welcome to the Adulting Demystified podcast with your host, Odelia Goldberg. In each episode, we'll have subject matter experts discuss things that most people don't know, but probably should. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcast, Spotify, and on our website, ogoldberglaw.com. Now, here's the host of Adulting Demystified, Odelia Goldberg.
Hi, everyone, and welcome to another edition of Adulting Demystified. Today, we are so excited to have Craig Redler join us. Now, Craig is a fellow attorney here in South Florida, and his area of specialty is asset protection. And Craig, I don't even know how you and I know each other, but I feel like we know each other for years and years and years. And I'm happy to say, that you have helped out quite a few of my clients that, need additional asset protection. I do the basic estate planning and sometimes we need to crank up the heat a little bit more, then I'm happy to make that introduction. And just as a recap, the point of this podcast is to kind of demystify some of the common misconceptions that people have. When I was going about my estate planning, I realized that most people really don't know what a will does or what probate is. And I thought to myself, I bet, in other areas, there's these common, things that people kind of get wrong. And wouldn't it be great if we had a forum of subject matter experts that were able to come on and kind of clear up some of those things that people don't quite get. So Craig, I want to just say thank you so much for joining us today.
Oh, God, it's my pleasure. Thank you. Appreciate you having me.
Yeah. And so just as an intro, is there anything that you want to share with the universe to clear up a common misconception about what it is that you do?
Yeah. Well, let me start with this. So just as a foundation, I do asset protection. So what does that mean? That means I try and build firewalls around my client's property. So if they get sued, the creditor can't come and take it. Right. So just again, by way of foundation, if you get sued and someone gets a judgment against you, they can generally just ask the court for what's called a writ of execution or a writ or a take back order or something like that, and come in. Different states have different names for it, and can come and take your property. So if you take with the most basic property that we all own, to cash in a checking account. Right. If I were to get a judgment against someone and ask the court for writ of execution, I can go to where they bank and I can hand the bank this writ of execution, and the bank's going to hand me that cash. So what my planning does is it makes that impossible.
Amazing.
So most people don't know that's a thing. Most people just think, all right, if I have an LLC, if I have insurance, I have asset protection. Well, we can do it. You can do it in a much more robust manner than simply. I mean, that's a start. You want an LLC, you want insurance, but sometimes you need something a little more robust. So one of the tools we use, and one of the many tools. So I'm going to get to the point. It's a very long answer to a short question. One of the tools that we use, and one of the primary tools, and one of the best tools, is offshore trusts. So most people hear offshore, and the first thing they think is, oh, that's outlaw stuff. That's tax evasion. And that couldn't be further from the truth. The offshore is really effective for protecting your assets. Nothing illegal about it. We're not hiding assets. We're not evading taxes. All of that's transparent. All of that is compliant. But it merely is a planning tool to protect your assets, just like buying an insurance policy, just like having that LLC, just like jointly owning things. So sorry, that was probably a much longer answer than you were looking for.
No, that's perfect, because when we talk about asset protection, it kind of, people come to me and they're like, I want asset protection. I'm like, from what? From a divorce, from death, from liability? Is there a creditor knocking on your door? So asset protection in general is a very broad category. We generally want to kind of drill down and see who we're protecting from. And that kind of speaks to the solution that we can give people. I tend to think of you as the person that when people are knocking on the door, right, we know that there's a litigation. We know not that there's a potential creditor, anybody can get sued at any time. But when we really have someone that is there available to us, and we know it's coming down the pipeline. So that's usually how I discern when I kind of pull you in to our client meetings. But you let me know, maybe that's a misconception.
Let me explain that. It's certain. Look, if their hair's already on fire, my toolbox is about that wide. If I'm talking to someone while their financial seas are calm, my toolbox is considerably bigger. So it's like buying insurance. You really don't want to buy insurance after you've had a car accident.
Right.
You want to get this planning in place prior to a claim. Now, having said that, there are a couple of things we can do to put you in a better place if there's a claim already pending. And the claim actually can be as broad as, and when I define what a claim is, nobody's ever gotten sued just completely blindsided by a lawsuit. I shouldn't say nobody, but it's pretty rare. Right. So I started my career as a litigator and defense side, and clients would always come in. And actually, I did some what's called subrogation work, which the one-time defense attorneys actually are plaintiff's attorneys beyond the scope of this. But you start every suit typically with a demand letter. And you've seen them, we've all seen them, dear Mr. So-and-so, please be advised I represent Ms. So-and-so, who I understand you entered into a contract. Pursuant to the contract, you were supposed to do X, Y, Z, you failed to do so. Accordingly, you're in breach. You
just summarized the demand letter so beautifully. I love that.
you can tell I've seen a few and maybe even written a few. But when you get that, that's a claim. So that already is going to limit what I can do. Ideally, you don't want to wait for that. So having said that, it helps define who's a good client. So there are some people that are just naturally going to be better candidates. And by better candidates, I mean more interested in this than others.
Right.
For example, if I may, take two clients. And I, a lot of people, a question I always get is, how much money do you need? And we'll talk about that in a minute. But look, if you have nothing to protect, you certainly aren't going to go to the effort. So it's typically people of means, but not always. But take two clients that do have means, all right, and say they're not ultra high net worth, but comfortable. And some people may hear this and go, well, this guy's definition of ultra high net worth, I don't know, but just say they have $10 million, all right, which is certainly by any definition pretty comfortable, but still in a position where you can get really, your lifestyle can change from a bad lawsuit. Sure. So two people with $10 million. Client A is a C-suiter at a publicly traded company. Now, publicly traded companies, of course, get sued all the time. If you're Microsoft, Amazon, Google, General Motors, they probably get sued somewhere in the world 10 times a day, and that's probably not an exaggeration. But the executives are not going to get named, all right? And if for some odd reason you're going to name someone personally, in all likelihood, the company is going to indemnify them. Sure. So, the chief executive, chief financial, chief whatever at Google is undoubtedly a wealthy person. But if Google gets sued, that person, his or her personal money is not going to be exposed. But contrast that to another client who maybe has the exact same $10 million, the bottom line of their balance sheet. But that client, as opposed to working in a publicly traded company, has a chain of restaurants or a manufacturing facility or whatever they do, and they've got 100 employees. And in my world, you have 100 employees, you have 100 potential plaintiffs on your hands at any given time. So that person, client B, is going to be a lot more motivated to do this kind of planning than client A, just because the threat of a lawsuit altering their lifestyle is just real, a lot, something they're thinking about a lot more often than that CEO at Google.
Sure. Are there any downsides, or what are some of the risks to offshore accounts? It seems to me just an unknown thing. People hear about it, but it's not very common, I suppose. So what are we know the upside, right? But what are some of the downsides to consider when, kind of introducing this into a plan?
Well, two things. First, the nature of the tools themselves. So if we're going to go offshore, and I'm going to just throw out some legal gobbledygook, it is the trust, the asset protection trust is in the form of, and lawyers will appreciate this, a self-settled discretionary spendthrift trust.
Okay.
All right. So self-settled discretionary spendthrift trusts are by their nature a little off-putting for some people, and here's why. It's that word discretionary. All right. So most of the trusts that we do, and most of the trusts you're going to see, and most of the trusts that people are familiar with are I should say they're not discretionary. They're what's the word I'm looking for? The settlers are also the trustees. So what is
Yeah,
the
the
word?
grantor revocable trust with a
Grantor
grantor.
trust.
The
There you
trustee,
go.
the
Okay, thank you.
beneficiary, absolutely.
I just totally drew a blank there. So when you set up a revocable living trust, the common estate planning trust, it once everything's in place, you're not even going to know it's there.
Right.
You sign your own checks, and you will continue to sign your own checks. If you want money from an account owned by that trust and you're used to going to the corner ATM, you can keep going to the corner ATM.
Right.
With these things, the way they work is you have to give the trustee discretion to allocate resources from the trust.
Gotcha.
And the trustee is not going to be you. All right.
Can it be a spouse, or is that too?
If it's the perception that you have control, if it's a spouse, is going to be there.
Gotcha.
So typically, and the better way to do it, and depending on what state you're in, you almost are forced to do it this way. And this way, I mean, is the jurisdiction you choose also. So that would have been that's going to be my second potential concern. But let's go back to this discretionary thing for a second. You can't just go to the ATM and get money out of one of these.
Right.
If you want a new car, you have to write a precatory letter. I call it a letter of wishes to the trustee. And you have to say, dear trustee, I know I can't force you to do anything, but it sure would be swell if you'd consider giving me $50,000. I want to buy a new car.
Mm-hmm.
So a lot of people so I have to ask someone for my own money. And the answer is yeah. But I can tell you that the trustees we use understand their role. All right. So from time to time, you and I both set up trusts for families will come in and go, hey, lawyer, I've got 3 kids. 2 of them I've got no problem with. I love them all to death. 2 of them I have no concerns with. Third one, great guy. I love him to death. But he's just not the most responsible guy in the world. And I really don't want to give him unfettered money. So can we set it up to where somebody's looking after his money? And that's the idea. And we've also both gotten this call. I know, hey, trustee, I need your help to get rid of hey, lawyer, I need your help to get rid of my trustee. And
Sure.
of course, the first question is going to be, well, why do we want to get rid of the trustee? And they'll come back with something like, well, he won't buy me a Corvette. And so for a trust like that, where the trustee is literally charged with, don't let this beneficiary do anything stupid with this money.
Right.
Look after him or her. That's their job. The trustees that we use for these trusts, they understand that's not what they're asked to do. Mm-hmm. They're asked to stand between you and your creditors.
Gotcha.
They will do virtually anything you ask them. And there are only going to be 2 exceptions. So the only time they won't do what you ask them is if you ask them to do something that is so beyond the pale of what is reasonable that it would be literally a breach of fiduciary duty if they were to do what you ask them. For example, hey, trustee, I need you to send me $20,000 because I want to buy a truck full of cocaine and take all my friends to Las Vegas. They're not going to do that.
Fun, but not permissible.
Well, exactly. Something that literally, if you asked your trustee to do that for you, and the trustee was to grant that particular request, and you woke up on Monday morning and the haze lifted, and you go, oh my God, what did I just do? And you called the trustee and said, trustee, why on earth did you let me do that? I'm going to sue you. And you sued them, you'd win. I would take that case all day. So they won't do anything that's just completely insane. And then the second thing they won't do is they won't do anything if you are under duress. So that's where the asset protection comes in. Mm-hmm. All right. So, hey, trustee, I've got this judgment against me. I've been ordered to take the money out of my bank account and pay it over to this creditor. Will you please do that for me? No, we're not going to do that. You're under duress.
Gotcha.
Those are the 2 times they're going to say no. Now, I will tell you also the way I draft my trusts. So some people who are listening to this may say, well, all right, that's still not good enough, Craig. You say they'll listen to me, but what if they don't? Then what do I do? I always build a safety mechanism just for that.
Sure, backdoor, we call it.
Yeah, a backdoor. That's exactly right. We would appoint someone that their role is officially called protector.
Oh, a trust protector. Oh, good.
And the trust protector is just that. His and her job is to protect the settlor and beneficiaries from the trustee. Gotcha. I will suggest again and say till I'm blue in the face, the trustees that I use are professional. They're licensed or bonded. they've been in the business a long time, you do not need protection from them. But
Right.
nonetheless, if you're a client and we just meet, you're taking my word for it, and you have no personal experience with this trustee. So, all right, Craig, well, you seem like a decent enough guy, but still, I don't believe you.
Right.
Well, it's okay, client. I will install this back door, this protector, and here's how that works. So the protector actually does two things. And stop me if I'm getting too far off track here.
No, I love this. This is you're
so-
you're speaking my language. I love it.
You and I are both trust nerds. We love this stuff, right? So I gotta speak for yourself, nerd. But anyway,
Oh no, I identify as a nerd, not just a trust nerd. Yeah, I'm a big dork. Yeah.
So anyway, the protector's job is to protect you from the trustee, like I said. And this concept was invented back in England 1,000 years ago, where people were going off on crusades and they needed to leave their property with somebody while they're out fighting in a crusade. And well, even now, people, you pick your brother-in-law as trustee or something, and sometimes you need protection from trustees, not the trustees we use. And how that works is the way the trust is written is that the trustee makes all the decisions, but nothing happens until the protector signs off on it.
Oh.
So say, for instance, you were to say, trustee, I need money to buy a car. Trustee says, approved, we'll take care of that. We're going to wire you out some money so you can buy a car. They do the bank order, getting all ready to do the wire. The bank knows that they're not going to do anything unless or until the protector signs off on it. So the last step is the protector is going to get a copy of the wire transfer order and has to sign it and has to approve it or decline to veto is typically the context. So how does that work? You're making sure that the trustee itself is not stealing from you, is not doing something stupid.
Yep.
So what's going to happen? I make that request. The trustee approves it. It goes to the protector. The protector is going to call me and say, hey, Craig, trustee's just about to fire some money from to buy a car to you. Do you ask for that, right? Answer is yes. Or yes or no. Either I did or I didn't. So assuming I did, then the transfer goes through, no problem. If I didn't, then it stops. So why would they call me and ask me that if I didn't? You're being protected if the trust from the trustee stealing from you. Okay, so it can't just be an employee of the trust company, because the protector is someone who's not with the trust company. It's someone else. So you're making sure the trustee itself can't steal from you. And then the second thing that's going to do is protect you from outside fraud. So if you've got some kid in China or some kid in Russia who's been intercepting your emails and knows these conversations you have with your trustee and is trying to steal out of the account, it gets intercepted by the protector. So that's great. That's job one of the protector. Job two of the protector is you empower that protector to get rid of the trustee for any reason or no reason. So here's how it relates to what I was talking about earlier. Hey, trustee, I need some money for a new car. Will you please wire it out to me? Hey, Craig, we like the car you have. We're not going to do that.
Right.
And at that point, I can go, oh, well, that's too bad. You're fired. Hey, protector, get rid of this guy. And that's how I've got my backdoor control.
Yeah, that's how, I also use trust protectors. Oh, and not too often, but sometimes we need another level between the beneficiaries and the trustee. So we put it in there so that the beneficiaries don't need to go to court to amend the trust or to replace the trustee, so they have some recourse. So yeah, I use trust protectors too. That's funny. Yeah, great.
Yeah, but to your point, it's extremely difficult if you've got a trustee that's misbehaving and like investing in risky real estate deals or playing craps with your money. By the time you go to court and get rid of them, it could take, the damage is done. So yeah, it's good to have that in place, that safety valve.
Yeah, most often I find that when trustees go awry, it's not usually, sometimes, but usually it's just they're unresponsive. They don't understand the gravity of the position and they don't get back to the beneficiaries or not quick enough. And then you lose kind of faith and you lose that goodwill. They don't often do the accounting that's necessary, that yearly accounting. And then once that goodwill is eroded, it's really hard to kind of repair that relationship. So, that's where it kind of goes, it starts little by little, slower response time, slower feedback, and then it kind of escalates to, I hate them, they're not doing what they need to be doing,
In
so
there.
yeah, we try to kind of
That's also why, going back to, sorry to cut you off, but we use, by and large, we're going to recommend a professional trustee.
right.
And that's not to say that they don't drop the ball from time to time. They do, but the likelihood of that happening is much smaller. And if they really drop the ball to where it costs the beneficiaries money, they're going to stand behind it. So, but when I'm talking about professional trustees, you had mentioned maybe it's the spouse or something like that. There are 21 states that recognize these discretionary or these irrevocable discretionary spendthrift trusts as asset protection vehicles, which means there are 29 states that do not. So typically, where you and I both are, you're in Florida and I'm in California right this minute. These are two states that don't recognize these things as asset protection vehicles. So if you're in a state like California or Florida, what do? My suggestion is we'll go somewhere else. We'll go to a different jurisdiction and set it up there. So most of the jurisdictions that are top tier trust jurisdictions have a requirement that the trustee be within the jurisdiction. So if you're going to set up a trust overseas, say for instance, my go-to jurisdiction is typically going to be the Cook Islands, and Plan B is going to be Nevis in the Caribbean. Both of those countries have a requirement that if you're going to have a Cook Island trust, you need a Cook Island trustee. If you're going to have a Nevis trust, you need a Nevis trustee. Most of the top tier jurisdictions in the USA, and there are 5 states that are always mentioned when you're talking about top tier jurisdictions in the USA: Nevada, Wyoming, South Dakota, Delaware, Alaska. All of those states have built quite a nice trust industry. It's funny. I mentioned that offshore scares people, but this is something that would be a shock to most Americans. The biggest offshore jurisdiction on the planet Earth, in terms of how much money is domiciled there, is the United States of America for non-Americans.
Right.
There is more foreign money in Nevada and Wyoming and South Dakota and Delaware and Alaska than there is in the Bahamas, the BVIs, the Caymans, the Cook Islands, on and on and on. The United States is where people come to offshore if you're not a U.S. person.
Yeah, I believe it. Yeah. That's hence the FinCEN rules,
No. But part of that is, and this is interesting too, this is just a fun bit of trivia. Again, going back to this question, people go offshore to evade taxes, and I'm not going to insult anybody's intelligence and tell you it's never happened or it didn't used to happen frequently. I can tell you with a completely straight face, it sure doesn't happen a whole lot anymore.
Right.
And one of the big drivers of that is some legislation called FATCA, the Foreign Account Tax Compliance Act. And what FATCA does is it compels foreign financial institutions to report to the IRS in the same way that an American bank would.
Sure.
So if you've got money at a domestic bank, and you have money at Bank of America or Chase or Wells Fargo, and you earn $100,000 on your account from interest and dividends or whatever, you're going to get a 1099 from that bank, and you better report it on your 1040, that income, because the IRS already knows about it. Right. And yeah, back in the day, if you were in Switzerland, sure, you had an obligation to report income in your Swiss account, but if you didn't, oops, how are they going to find out? Well, today under FATCA, they'll find out. The Swiss banks and banks and everywhere else is going to be reporting it. So what's interesting is FATCA is an American law. And it is something that we unleashed on the world, and we said, all right, rest of the world, if you have any American customers, you're going to need to report to the IRS, and if you don't, we're gonna cut you off from U.S. dollar trading. So that was the big stick. How does the United States get a Swiss bank or a French bank to do anything? Well, that's the stick they use. U.S. dollar is the de facto reserve currency in the world, and most foreign transactions are done in USD. So even if it's two countries that aren't the USA, if you're in Italy, you want to buy something from Japan, Japan doesn't want euros, they want yen. They're all going to be going to trade your euros for dollars, trade your yen for dollars, do that transaction in dollars. And so it's necessary for almost all foreign trade. But anyway, so the USA unleashes this FATCA beast, and it was a beast. It was just the compliance with this thing is insane, off the chart. So the rest of the world put their head together and said, all right, the USA is making us do this. We trade on US dollars. What do we do? A couple people pushed back. A couple banks said, we're not doing that. And those banks are currently out of business. I could name a couple. Like literally, the United States put foreign banks out of business, old ones, for not complying with U.S. mandates. USA is the only country in the world with enough influence to do that, which is how we get away with it. But so we can either push back. That didn't work out very well. We can do nothing and just go, all right, USA, you win. We're just going to comply. Or third option is, well, if it's good enough for them, it's good enough for us. And that's what they did. So under the umbrella of something called the OECD, the Organization of Economic Cooperation and Development, all the countries of the world put their heads together and came up with a parallel statute of FATCA called CRS AEOI, Common Reporting Standards Pursuant to Automatic Exchange of Information, AEOI, pursuant to Common Reporting Standards. So no matter where you are in the world, if you bank anywhere you're going to want to bank, any country that's not signed on to this treaty, you don't want to bank in. But say you live in New Zealand and you open a bank account in Mexico, that Mexican bank's going to report back to the tax collector in New Zealand, we got one of yours, here's how much they made this year, and vice versa. So there's one country in the world that decided we're not doing that. It's just too expensive for our banks to comply. Can you guess who it was?
I don't know. What? Who?
Well, here's the hint. We're all sitting in it right this minute.
Really?
So the USA said, we're not doing that. They invented FATCA. CRS-AUI was just a response to FATCA. And when asked to play along, they said, no, we're not doing it. You're going to do it for us, but we're not going to do it for you.
Really? Look at that.
That is one of the drivers. That's why so many foreign or non-US people are coming to the USA to set up these trusts, because they know that the USA is not reporting back to their tax collectors.
Gotcha. And also, investment cash is also kind of protected here in the United States versus in other countries.
And the institutions here are good. The banks here are good. The courts will enforce a contract. That they're going to, regulators in whatever state you're in, the Nevada regulators are going to protect you from the trustees. So there's a lot of reasons to come to the USA. But boy, that whole kerfluffle with FATCA is certainly not a small part.
How long ago was that?
2014 is when FATCA came out, and CRS-AUI, I want to say 2017, 18, something like that.
Fairly new.
Recent. Relatively, yeah.
Do you think that with the crypto and the new money kind of situation that they're talking about, things would change, or no, it's not going to impact anything if, currency kind of changes in the way that we view it right now?
There is certainly nothing that any of the world governments can do if I've got, $10 million in Bitcoin on a USB drive and I mail it to North Korea or something like that. It opens the door to things like that. But in terms of any kind of institutional control over those kind of assets, if you're going to use Coinbase or Gemini or something like that, yeah, absolutely. I think those exchanges, those large exchanges, or even the smaller ones are going to be 100% responsive to what government mandates they do. And they're all reporting now. I know they are. So.
Good. So I have a question for you. You mentioned that the offshore trusts are irrevocable trusts. Can they also be leveraged for, we talk about asset protection, but estate tax asset protection? Yeah,
1,000%. So the trust that I've been talking about is a self-settled discretionary trust. Self-settled trust means that the settlor is also a beneficiary. So to take advantage of the large exemptions we have right now, and it probably requires a little foundation. Estate tax, the way that works is, and you know this, but people watching may not. The estate tax exemption level is set in the law. If you have below that the exempted amount, you don't pay. If you're above it, you pay anything above it. So right now just a couple of days ago, January 1st, it went up to $13.9 million per person. So I could die with up to $13.9 million. I could leave it to my kids. There's no estate tax. If I die with $20 million, the first 13.9 I don't pay tax on. The additional 6.1 I'm going to pay 40%. It's a high tax. So that law, the way it's written right now, is changing January 1st, 2026.
Mhm.
It's literally getting cut in half. So from 13.9, the way the law is written, it's an inflation adjusted from 2017. So who knows what next year what that's going to look like, but figure between 6 and 7, it's going to drop from 13.9 to between 6 and 7, let's say. So if you're someone who has $10 million today, well, you want to take steps to preserve that exemption, because if you live into 2026, you're going to go from a non-taxable estate to a taxable estate.
Sure.
So to your question, yeah. So what we do is we alter the trust a little bit, and it becomes what's called the opposite of a self-settled trust, a non-self-settled trust. So it's a completed gift trust. So also the way the law works is it sometimes hear the term unified credit. So unified credit means it's a estate tax and gift tax, estate and gift. You sometimes hear them linked together. So I mentioned if I die with this much money, what I didn't mention is the IRS keeps track of how much you gift during your lifetime.
Oh yeah.
It's going to keep a running total. So when you give away this year, there again, you can give up to, what is it, 19,000, I think. I don't know if it went up on January 1st.
No, 19. Yep.
Yeah. Okay. So it's $19,000 per person per year. I can give away $19,000. I don't have to file a gift tax return. If I give away 20, I do. So the IRS is, if I give my kids today a building and it's worth $3 million, I have to file a gift tax return. They're going to lop that $3 million off whatever the exemption is on the day I die. So what we want to do is we want to give those gifts today, and no matter what the law does moving forward, you've utilized that exemption. So I would give as advice to anybody that has over $13 million to consider doing some form of non-self-settled trust today. Fund it. You can still benefit from the income generated from whatever property's in there with some good legal advice. And then if you die past 2026, you gave the property away when the law was in your favor. Your grandfather. You're not going to have to worry about the estate tax. So we will make it a non-self-settled trust. But yeah, again, very long answer to a pretty short question. Sorry about that.
Amazing. And then one other question, what is there a difference if the client is real estate heavy, right? Because some clients aren't cash heavy. They invested in real estate. That's really where the bulk of their assets are. Is there, people come to me full of LLCs, single member LLCs sometimes. And, we try to do some kind of, because from my perspective, an LLC doesn't avoid probate. So I say you might get sued, but you're definitely going to die, So I look at it like, people are scared of getting sued, but, really death is a more imminent danger that we have to plan for. But LLCs and real property tends to be, they kind of go together for people, even though in my mind's eye, they're not a really great marriage.
Yeah, it's a great question. And the answer to it depends on where you live. So, but first, as to LLCs, one thing got to keep in mind is they are an asset like anything else.
Yep.
So if I have an asset, or I have an LLC rather, and it's got $10 million worth of property in it, and I get sued for something I have to do, or something I did outside of the LLC, breach of contract, a tort, I injure somebody, whatever. The LLC is potentially an asset that creditor can take by way of one of these writs I mentioned. Some states have different laws on that. It's charging order protection and things like that. But good attorneys can sometimes sidestep that. So an LLC, ideally, what it's supposed to do is it's supposed to ring fence the rest of your property from property outside of the LLC. So if I have a rental property in my LLC and someone gets hurt at that rental property,
right,
and say that property is worth $3 million, but I have $10 million worth of other stuff not in the LLC.
right,
and I get a massive lawsuit, theoretically, all that plaintiff can get is the $3 million equity in the property that was in the LLC. The other $10 million outside of it is supposed to be safe.
Right.
Now, having said that, any attorney will tell you that there are any number of theories upon which it's called piercing the corporate veil.
Sure.
And I, on small closed corporations, I would not rely on them. Most people don't manage them correctly. And
no meeting minutes. That's the first thing is, where's your meeting minutes, people? Yep.
1,000%.
Yep.
So I wouldn't rely on that. But anyway, what you want to do is you want to protect yourself from inside liability and outside liability. Yep. So even with an LLC, even the LLC membership should be funded into a more robust creditor protection vehicle. But to your question about the real estate specifically, that's a great question. So I mentioned earlier, 21 states recognize asset protection trust, 29 don't. So for cash, we go outside the jurisdiction, no big deal. That's easy. Real estate, you cannot pick up your real estate and move it to the Cook Islands. All right. You can't pick up your real estate and move it to Nevada unless, of course, it starts there. So what do you do with real estate in Florida or California or one of these other 29 states that don't recognize these things? And the answer is not an asset protection trust. Right. So we're going to use different techniques. It usually is going to involve either allocating debt,
right,
or going to this non-self-settled trust that we talked about earlier for estate tax planning. Mm-hmm. They also work pretty good for protecting real estate assets. So funding one of these trusts is no different from a court's point of view as giving a gift to anyone else. The trust isn't you, you're not it.
Sure,
okay,
sure.
You're different entities. You make that argument with a self-settled trust. In the states that don't recognize asset protection trust, you lose. In the states that do recognize them, you win. So if you have Nevada property, no big deal. You can put it right in an asset protection trust, you're fine. If you have Florida property, you need to put it in a non-self-settled trust. So circling back, that is no different than if I were to gift it to you. I thank you very much for inviting me on this podcast. And I, as a token of appreciation, I deed over a parcel of property to you. And a year from now, I get sued. And somebody comes to you a year after that, after they have a judgment, and go, Odelia, we sued Craig. We know he gave you that property last year. We're here to take it. You can say with a perfectly straight face, well, it isn't his anymore. It's mine. You didn't sue me. Get out of here. You'd win. Okay. So the non-self-settled trust works like that. So next question is, all right, well, God, it's got these tax advantages and it will even work in non-DAP states. Why doesn't everybody use a non-self-settled trust? And the answer is because you're not a beneficiary of a non-self-settled trust. So it's more difficult to benefit from using your own property. You would never put cash in one.
Right.
Okay. Because if you want trustee, hey, trustee, I need some money to buy a car. Trustee would say, well, you're not a beneficiary. I can't send you money.
Right.
So and there's additional filings and things like that. So when someone comes in with an estate that's going to consist of liquid assets or bankable assets and real property, sometimes we'll do two trusts. Well, we'll do a regular asset protection trust and then one of these non-self-settled completed gift trusts.
Gotcha. What about making a beneficiary of a trust another trust?
Oh, absolutely, positively. If there is a reason to do it, that is certainly an option. And people would have any number of reasons to do that. So it's not unusual at all, really. And sometimes your beneficiaries have trusts. Or the other thing, this is interesting too, with the trusts that I do, a lot of them will take the form of what's called a dynasty trust. And that is to say that they continue on past the death of the settlor.
Well, now in Florida, they changed the and a trust could last 1,000 years.
Yeah. So that is
perpetuities is no longer an issue. 1,000 years. Yeah, it feels like a very long time.
Yep. So, and for pretty much all practical purposes, it is forever. You're not going to go. If someone comes in and said, I want to set up a trust for my heirs in perpetuity, and there's enough money to do it. Okay, if we do it here in Florida, it's only for 1,000 years, and no one's ever going to go, well, what happens year 1001? And my answer would be, well, we'll let them worry about it. Right?
We let them deal with that, yeah.
But so unlike the revocable living trust, which a lot of those are, when I die, everything to my spouse. When my spouse dies, or if my spouse predeceases me, equal shares to the kids. So they distribute on the death of the settlers. These things, it's just like we have 4 beneficiaries when we say there's 2 kids, mom and dad, 2 kids. 4 beneficiaries when we settle the trust. Dad dies, nothing happens with the trust. Now there's only 3 beneficiaries. Mom dies, but there's a grandkid. There's still 3 beneficiaries. So they just go on and on.
So before we leave, I just want to get your thoughts, because I could talk to you for forever. Honestly, trust is my love language. So, for me, you're truly speaking my language, but I just want to pick your brain and see, what do you have to say about the Florida Land Trust? Because I love the Florida Land Trust. I think it's a much better tool than an LLC for real property. Again, I look at the world through the lens of probate. I know you and I kind of see the universe a little bit differently, and that's what makes it awesome. But from a probate perspective, the land trust is a much cleaner, more elegant approach in my mind.
I would agree. I would agree. Look, a lot of people call me and ask about those, and they're fine. And my take on a land trust is they're people that are looking for anonymity.
Right.
Is really where they fit.
Yep.
They don't really do anything in terms of asset protection. They will check those boxes for estate planning, for probate avoidance, and things of that nature. It depends on what you're looking for. And that's, look, every conversation, you and I are the lawyers. We don't tell people what they need unless they ask us.
Right.
So what's your situation? What do you want to see happen, client?
Right.
Now, if there's something that a benefit they could have that they don't even know exists, and I don't even know that's a thing, then certainly, we're going to want to educate someone. But at the end of the day, people tell us their situation, and we say, well, here are your options. And then they say, well, all right, I like option 1 and 3. I don't like 2 and 4. And that's how it works. So, if you sit down with the client and the client says, I just want to make sure nobody even knows I own this. If I get sued, I don't want someone to be able to see it, where they can come. Land trust, it works wonderfully.
So I had that happen today. Actually, someone called me and they had a different goal. And it was someone that worked at one of the large banks. And he said, I own real estate. Right now it's in an LLC. I have one in an LLC, and I'm thinking about putting them all in LLCs. And I said, let's talk a little bit about maybe a trust, whatever. And he said, well, does a trust allow me to get credit against, because if it's an LLC, then a lender will give a business credit, right? Give a credit card, and you could establish business credit against an LLC, allegedly. It's kind of a bit scammy to me, to be honest, but So I said, is that your goal? And he said, yeah, ultimately that's my goal. I work for a bank, so I know for a fact that with an LLC or a corporation, we're able to establish a credit, score, so to speak, and build credit, and I could borrow against it, and I could have a credit card. Can I do that with a trust? And I said, well, talk to the bank and see if the bank will let you. Probably not, because a trust is so new and they're so super uncomfortable with it. But that was the first time I had heard someone's goal not being creditor protected, probate protected, anonymity, tax. Yeah, it was a new one for me, because I hadn't considered that as even, one of the lanes of the highway of what people would want.
Here's what I would have told that guy, though. Be aware of the Corporate Transparency Act. Right now, it's stayed right this minute, and this is the beneficial owner database that FinCEN's going to keep on all of us now. And that was very common that people would come in and I've got 13 rental parcels. I put them in 13 LLCs, which for a creditor protection point of view is great. Look, if you've got 2 in one LLC and I get hurt, I can take the equity out of both of them. Or if I have each of them in their own, I can only take the equity out of the one I got hurt in, right? So it made a lot of sense. But God, with the Corporate Transparency Act, now I've got a whole new level of reporting on each LLC, maybe. Curious how that's going to turn out. It's just another whole layer of work when setting up these LLCs and layer of administration, and it complicates those even further. Trusts are not subject to the Corporate Transparency Act reporting. Yeah. Yeah. So,
I thought that they were, but it turned. Nope. Oh, really? Oh, that's good news. That's good news indeed. Well, good to know.
Another good reason to support, like, substitute trust for LLCs when you can, if you want to avoid that.
So many reasons. I made a whole video about it. Should I put my income producing property in an LLC or trust? I'm like, put it in a trust. But, ultimately everybody has their own, kind of goal in mind. Well, Craig, I really appreciate you speaking with me today. I know I learned a lot, and I want to just give you an opportunity to have any final thoughts or tell the people where they could find you if they have more questions.
My website is www.redlerlaw.com. And what I do, there aren't a ton of people that do what I do. And I didn't mention this, which is amazing, because I will tell anybody who listens, because it helps them remember me. I am the only lawyer in the United States that has ever lived and worked in the Cook Islands in the industry.
Oh,
Right? So
really?
I actually was general counsel for a trust company in the Cook Islands. So I worked at trust companies in both the Cook Islands and New Zealand, doing this kind of work. And again, why the Cook Islands? Cook Islands has the best statutes in the world to protect assets for Americans. The statute was actually written by an American lawyer specifically with protecting Americans in mind. So it's still the best jurisdiction in the world for it. And so I've got a unique experience, and it helps people remember me. Oh yeah, you're the guy who lived in the Cook Islands. So you got to come up with an angle when you're as plain vanilla as I am. It's like, oh, middle aged, middle height, brown hair.
I don't find you to be plain vanilla.
Picture me in a grass skirt. You won't forget. So.
Amazing. Craig, thank you so much. I really appreciate you. Have a wonderful day.
Thank you so much for having me. It's been fun.
You've been tuning in to the Adulting Demystified podcast with your host, Odelia Goldberg. You should never get legal advice from a podcast. Please don't do anything stupid and ruin it for the rest of us. You deserve to have your own legal advice from a legal professional. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcast, Spotify, and on our website, ogoldberglaw.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.